Our next item is item number 9 on the agenda. Ian, our annual fiduciary training.
You're the keynote dinner speaker, Ryan.
There's gonna be jokes.
We are
right?
not going to put you off again, I am
Interpretive
honest.
dance.
We are with you.
I'm just saying.
You can see my favorite fiduciary Dana because of the flowers.
You sure it
Hiding.
wasn't Mulvaney's?
I'm hiding.
All right, let's see if I can get this to go. Okay. Good afternoon. I guess part of your fiduciary duty is listening to me for some time here, talk about your fiduciary duty. I try to make it interesting. I hope I've succeeded, but please, I invite you to ask questions or make comments as I go, rather than me just talking. And usually that's not a problem. The first slide just establishes that the board's authority over the assets and administration of CalSTRS is established both in the Constitution and the teacher's retirement law, the Ed Code. That's unusual to have the Constitution contain fiduciary language that applies to a pension system, but that's what's in the California Constitution. The language that is in both the Constitution and the Ed Code was taken directly from the 1974 federal pension law called ERISA, which means we use that as a comparison and touchstone, not because of the fact that it's word for word, because obviously state courts might interpret the same words differently than the federal courts, but because it provides best practices for us to examine when we're advising you. So, and there's been court decisions, Labor Department rulings since 1974, so it's very helpful to us to have that body of law. There is no body of law in California on the proper interpretation of the language. So it gives us something to look at. The Constitution adds a third duty, which is not in ERISA, to minimize employer contributions. This really hasn't come into effect because the language also states that the board's fiduciary duties takes precedence over any other duty. So to the extent that this board were ever to decide to cut back on employer contributions, it could only make that decision if that decision was consistent with its fiduciary duty. California law establishes a trust for CalSTRS, so the assets are held in trust, which adds another layer to the basic fiduciary language in the Constitution and the state statute. And there's hundreds of years of trust law that then also provides information and a backdrop to our interpretation of both the Constitution and the statutory fiduciary standards. And there's a famous U.S. Supreme Court case from the 1920s where the Supreme Court stated a trustee is held to something stricter than the morals of the marketplace. And that's something that that we follow closely. There is one federal law that has fiduciary standards that applies to CalSTRS. That's the Internal Revenue Code. The IRS really doesn't pay that much attention to the administration of public plans, but it is in the code. You're required to be administered as a qualified plan. You must comply with the exclusive benefit rule in the Internal Revenue Code, and you're not allowed to engage in a prohibited transaction. The only prohibited transaction that the Internal Revenue Service cares about would be if you were to divert assets of CalSTRS to either the state of California or to contributing employers. And there's also language in the Ed Code that prohibits that. So they're consistent. I'm going to talk about two basic duties, the duty of prudence and the duty of loyalty. I'm going to begin by talking primarily about the investment area, but later in the talk, I'll also address how these principles also apply to non-investment issues. The duty of prudence requires you as fiduciaries to discharge your duties with care, skill, prudence, and diligence. Due diligence is the primary key. I don't think anybody who serves on this board would ever say that you and the staff don't do due diligence. You do it in spades. I like to borrow a quote from a sports writer, Grantland Rice. It's not if you win or lose, but how you play the game, and that's really what due diligence is all about, dotting the I's and crossing the T's. If you do that, even if your decisions turn out to be disastrous, lawyers can defend them because you did your due diligence. No one expects you to know what the future holds. But if you do your due diligence, then you're prepared for the future. And that's something we drill in, and boards throughout all the years have accepted. As point of comparison, you look to other plans of a similar size and nature, and your staff does that all the time. It tells you what's going on in other places. You're not bound to do what other plans do, that's for certain, but it is required that you're aware of what other plans are doing. So for a long time, the trustees of this plan did not invest in hedge funds. I have another client, the Texas teachers, that at one time was probably the heaviest investor in hedge funds amongst any plan in the country, including public and private plans. And I was able to, advise both boards of trustees that they were prudent in making their decisions about hedge funds. So there's no one size fits all, but it's good to know, and it is a requirement to know what other plans are doing. If you don't have the expertise yourself, you're required to obtain expert assistance and advice. I represent boards that only make investments in Florida, for example, and New York, where the board members are required to have investment expertise. Here, some of you have it, and some of you have developed it, but you certainly didn't start with it. We make sure that you have expert assistance if you need it, with your staff, with your outside consultants. It is no defense that a decision was made in good faith. So good faith by itself is not a defense. I used to quote a court decision that said, an empty head and a good heart is not enough. And that basically is what that means. In ERISA, following the enactment of ERISA in 1974, the Labor Department interpreted ERISA in a way that allowed pension plan fiduciaries to take risk in their investment decision-making. When I first started with CalSTRS, the only investments were in fixed income. And when the legislature enacted legislation that incorporated ERISA language, we were then able to advise the board at that time that they could invest in stocks. For a long time, stocks were considered too speculative for investment. And this fund was one of the first funds in the country to invest in venture capital very successfully. It invested in real estate, all because we were able to interpret the language to permit measuring investment decisions against the whole portfolio. It doesn't mean you can invest in a pig in a poke. You still have to do your due diligence with respect to each and every investment. But in terms of overall risk, you're allowed to invest in riskier categories and riskier investments. And that's paid off. through the years, certainly with venture capital. For all the years, this fund invested heavily in venture capital. And then you're required to diversify the investments so as to minimize the risk of loss and maximize the rate of return. In the 1980s, the board at that time was advised by staff and outside consultants that it could feel safe and comfortable in investing a heavy amount of its real estate allocation to California real estate. The argument that was made was that you have Northern California, you have Southern California. California is so large. So the fact that, so you could have diversification even if you invest a large part of the real estate portfolio in California. Well, it turned out not to be right. Maybe everybody believed it at the time, but in the late 1980s, of course, there was a real estate crash, and all of the real estate in California took a bath. So you have to be careful with diversification and how it's interpreted and applied. The board, as you know, may delegate and does to staff and outside managers, and can do so as long as the decision to delegate is prudent and the board properly monitors the delegation. However, in terms of potential liability, there's specific language that gets the board off the hook when it delegates to outside managers, but there is no language that allows the same kind of delegation and protection when you delegate to staff. So through the years, it's made it particularly something we've been particularly concerned about. The more the boards have delegated to staff, how is the board protected? And staff and the board working together have, in my opinion, done an excellent job of and been very prudent in developing the useful tools that I hope you use by providing quarterly reports on their investment decisions, the staff video presentations, so that you have sufficient appropriate information. So you can, if anybody ever asks you questions, the worst case scenario, of course, would be in court. You're able to explain why you delegated to staff, why you continue to delegate to staff, and how you understood the steps that staff took when it was making its decisions about where to invest CalSTRS assets. Corporate governance is a fiduciary activity. Labor Department ruled in the 80s that proxy vote is a plan asset. So it's not only permitted that you be active in corporate governance, it's actually required, at least in terms of voting proxies. And the Labor Department has issued releases and regulations which go into this in more detail, which I won't go into. But basically, it's a cost-benefit analysis that's required so that when you take steps, it's pretty easy to vote proxies. It doesn't cost almost anything. But other steps that this board has taken through the years, becoming involved as lead plaintiffs or seeking to become involved as lead plaintiffs, voting on mergers and acquisitions, that sort of thing, involves costs. And so when we look at what your staff is doing and what you've approved, we're careful to make sure that the costs are worth it and pay off in benefits. Spent a lot more time with the duty of loyalty. It's much more, it's a more difficult concept to apply and understand. But you're required to act solely in the interests of participants and beneficiaries of CalSTRS and for the exclusive purpose of serving system members, providing them with benefits and defraying reasonable administrative expenses. The exclusive purpose: while performing trust business, fiduciaries may wear only one hat. I know that all of you have other positions, other jobs where you wear other hats, whether you're union representatives, union officials, whether you work for the state, whether you have businesses that you're running. You could wear those two hats, you just can't wear them at the same time. And that's a very difficult concept for a lot of people to understand and appreciate. In my practice, I've never had a problem here with people not understanding that. So that's something that this board and its predecessors certainly can be proud of through the years. There have been no problems, no scandals in this fund since the early 1980s, before there was really a board. There were only 3 members at that time, and there was an investment in real estate where one of the board members had a personal interest. I think it probably had something to do with the legislature adopting the ERISA standards. But since then, I mean, this operation has been clean as a whistle, and we haven't seen any problems. And that's certainly not true of some other plans we've seen around the country. I've had clients, go to jail. So this is also a little bit of a controversial slide that I use, but it's true. I mean, fiduciaries, when you're wearing your one hat, you have no duty of loyalty to the legislature, to taxpayers, to the union who appointed you, to the governor who appointed you, to contributing employers, or to California businesses. And Chris is going to talk tomorrow about California investments, and that's why this year I added California businesses. I never had that before. Economically targeted investments is a big topic here, as it is at most pension funds, particularly public pension funds around the country. So I want to spend some time talking about it. Economically targeted investments are transactions that take into account non-economic investment considerations. Any decision to invest must be exclusively grounded in economic considerations, but the duty of prudence does not require fiduciaries to invest in every investment or investment category. It's just that if you decide not to invest in a particular investment category because you don't like the kinds of things that the people who run those investments are investing in or excluding, you cannot remove them from consideration just on your personal feelings or social considerations. You have to have an economic basis for not investing in those particular products. And that's the basic rule. And there's no real divergence from that rule, and that's the rule that this board and staff have to keep in mind at all times. I'm sorry, go ahead.
Can you go back to the other slide?
Sure, I think so.
So how do things like our 21 risk factors and things like that interface with what you just said?
The 21 risk factors are economic factors, which you can take into account under your ESG policies and add to the mix of the considerations that you and staff take into consideration when you're making investment decisions. Now, I have some slides about ESG coming up, but basically, for example, fracking. A lot of people would consider that a social consideration, that people don't like what it does to the environment, rather than as an economic factor. But you've decided, with staff guidance and your consultant's guidance, that environmental considerations are actually economic factors. They're not really social factors. There's a social element to them, but they're not really the basis. So when you're bringing something like that into consideration, or your staff is, you look at fracking and say, this is an economic consideration which arguably adds to the risk of this particular investment or investment category. It may not be the total answer, because it may not be enough to render an entire investment or investment category imprudent, but it at least is something that's added to the mix as an economic factor.
Okay.
If in the end, the decision is made not to invest in that investment or investment category, the fact that fracking was part of your decision is okay, because it was just an incidental part of your decision.
The focus has to be on the economic.
But we focus exclusively on the economic. And that's been the law of the land now since 1974.
Tom?
Yeah, so how, there is this divestment movement, and people are endorsing it. They're fiduciaries. Is the rationale the indirect costs of these industries that ultimately hurt the equity portfolio, or are the people just taking chances?
Well, I think unfortunately, in many cases, people are just taking chances because they don't like the particular outcome of investing in Iran or Sudan or, in the old days, South Africa, or tobacco or guns. But we've developed a legal approach here at CalSTRS which permits a divestment under certain circumstances. And what we do is if an investment is not prudent, then of course, you don't have to invest in it. And your staff will tell you if investing, say, in tobacco is not a prudent investment. But if it's a prudent investment, and unfortunately tobacco has proved to be, a good investment, just like unfortunately guns, then there was something that I actually helped devise at the Labor Department back in the 70s called the Everything is Equal test, which provides that if you could find other investments of equal risk and return, then you can invest in those other investments, and you don't have to invest in the investment that you don't like. And we've used that successfully here through the years, I believe. Some more successfully than others. South Africa turned out not to be a positive investment. Divestment of South Africa turned out not to be positive here or anywhere else. And so, but fortunately, nothing bad ever. There was never a bad outcome as a result of that, in terms of trustees being sued or held personally liable. But and staff, tells you periodically about Iran and Sudan and tobacco, and will, tell you whether they can continue to use the Everything is Equal test to divest successfully from those kinds of investments.
So how does that apply if you're looking at correlations as well as absolute returns?
That is something you could take into account as well. It doesn't only have to be, absolute returns. It's also risks. It's also looking at other elements within the portfolio to measure against what arguably you might lose if you don't invest in tobacco.
What I'm trying to think of is we're indexed very heavily, but we try and discourage tobacco. We might, if there were a large gun manufacturer, we might not invest in that. And how do you then square that with an index target outcome?
Well, I mean, here,
You can
staff uses a non-tobacco index.
and it just excludes it.
Right.
So you have that variation.
But staff is supposed to be measuring the risk return of that index against the one that holds tobacco, and then periodically, I think it's annually, reports to you on the outcome of that
Right.
comparison.
I vaguely remember it, and don't remember any material results. But say it was a larger category like coal or oil and gas.
Right. Well, I testified before the Washington DC City Council when the City Council wanted to approve divestment of all oil and gas company investments, and talked about how at some point you reach a sort of a point where there's no way investment professionals can divest and replace that kind of investment within the, within the portfolio. Iran was a challenge. because so many foreign oil companies were doing business with Iran. Fortunately, some of them reconsidered, and your staff was able to advise the board that they were able to make other suitable investments in the portfolio using the everything is equal test. But, at some point, as the calls for divestment add up, you reach a point of no return, and oil and gas certainly would be one. And South Africa turned out to be one because there were so many large American companies that, that were included. That was just one that the power of politics was just too strong. There was just no way boards around the country were able to resist that. And so a lot of pension funds lost money, including this one. So I talked about the everything being equal test. I wanted to give you some examples of how strict the Labor Department is on economically targeted investments. In 2008, at the tail end of the second Bush administration, the department came under tremendous pressure from the Chamber of Commerce and to construe fiduciary rules more strictly than had been true in the past. So the Labor Department came up with new examples of how to apply these standards. And this one was a plan owns an interest in a limited partnership that's considering investing in a company that competes with the plan sponsor. The plan sponsor wants to influence its plan fiduciaries not to invest in that limited partnership. Labor Department, says no. There's a perfect example of two hats. There's, the plan has no interest in protecting the plan sponsor. It seems sort of counterintuitive, but that's the position that they've taken. We've talked about a somewhat similar issue here with privatization, where we've had conversations about how can CalSTRS invest in limited partnerships that in turn invest in charter schools, for example. And we really haven't had much of an outcome. Nothing really happened, but there was conversation about that. And teachers on the board quite rightly couldn't understand, my advice that at least theoretically, that's not their concern as trustees when they're wearing their trustee hat. But fortunately, I don't think we've ever really had to face that head on and do anything about it. Multi-employer plan wants to create local jobs. It's a good investment from a return and risk basis, but it's already made several loans of a similar nature in that same area, and the Labor Department says no, you would violate the duty of diversification. Plan wants to finance bonds for affordable housing. It's already done so. The bond it's considering at this point has a good risk and return profile, but is large and has a lengthy duration, which would interfere with its liquidity needs. Labor Department says no, you can't invest in that bond. This is one on environmental criteria. Plan fiduciaries decide they like environmental criteria so much that they're only going to invest in green companies. And the Labor Department says no. You have to look at companies on an overall basis. You can consider environmental concerns as part of that analysis, as we do here with some of the ESG factors, but you can't completely eliminate companies from consideration because you don't like their environmental practices, unless you use the everything is equal test. But you can't just do it without doing that. Union labor, that's how the everything is equal test was devised in the first place. It seemed crazy to us at the Labor Department, that union pension plans couldn't use union labor on their construction projects. So, that's how we came up with the everything is equal test, and we said as long as you can demonstrate that the union projects measure up to non-union projects, you can go ahead and invest in union projects. And for the most part, through the years, union plans have been successful in doing that. Every so often, they forget about their due diligence, and they get sued by the Labor Department. But that hasn't really happened as often as some of the people who worked for me argued would happen if we came up with the everything is equal test. So I'm happy about that. ESG, I already gave you sort of a nutshell analysis. But basically, again, just to repeat, what you do with your ESG 21 factors is you have authorized staff to take those 21 factors and bring them into the mix when you're considering making investments. And you consider, either they add to risk or they add to return. And if they add to risk, then you could consider that along with other risk factors when you're looking at the investment. It still may be possible to invest in those investments, even if, say, fracking adds to risk, if the overall investment is prudent. If you don't want to invest, even though the overall investment is still prudent, again, that's where the everything being equal test would be used. If the ESG leads to a positive outcome by adding to a particular investment, say clean energy, which you've decided and the board agrees is a positive economic factor, then obviously that's something that the staff will take into consideration. You still, again, repeating myself, have to take the overall investment into account and make sure the overall investment is prudent. Divesting, I've already talked about today. I just wanted to mention, we've had a couple of situations in the past few years where some of the board members have not been happy with some of the investments in our private equity investments, in our limited partnerships where we are not the only investors. And I just wanted, I said it at the time, and I just wanted to remind you that it's extremely difficult and challenging to approach general partners and attempt to get them to change their investment practices because of concerns about how something looks or how something plays to different audiences. It's not like public equity where you just use the divestment approach. It's very difficult to both divest limited partnerships altogether and then also to get a general partner to divest individual portfolio companies. And remember, you have other limited partners who may not see things exactly the same way as CalSTRS. So it's a daunting task for someone like Chris and the staff when they're asked by you, to talk to the general partners to try to get them to change their investment ways. And of course, the perfect example of that was the gun investment, which provided. And you'll hear tomorrow. I'm not sure that partnership has gotten rid of the gun companies to this day. I mean, we'll find out, but it's extremely difficult to do that, and it's something hopefully that won't come up very often, and that you can stay away from, because I don't like coming up here and telling you that you have to invest in guns.
Ian,
Yes.
do boards have with publicly held securities, divestment there's a difference between just selling one's holding and divestment. Is that correct?
Well, I would interpret those as being pretty much the same thing. Divestment also usually means don't buy more, but for the most part, it's getting rid of what you have. Okay, an aspect of duty of loyalty are prohibited transactions, conflicts of interest, and you have three types that are included in the Ed Code. First, with system members, which really doesn't amount to much. I'll talk about that briefly. Second, with an employer, either the state of California or the school districts that are contributing employers. And we've had a couple of dealings with that. And then third, self-dealing. And those are the most serious prohibited transactions under the Ed Code and under ERISA. And sometimes the most difficult to apply and interpret. The answer on having transactions with members and beneficiaries is just adequate consideration. And you really don't do that much, if at all. The only one I can think of through the years is the home loan program. And when that was first contemplated and then adopted, we made sure that the loans were treated as an investment and not as a benefit to STRS members, because that's the way you look at it under the law. And that's worked out. It worked out well, and the program was successful. We were told in the beginning, well, it's not going to work. No one's going to take one of our loans if it has to be comparable to what they could get if they just walked into a bank. But we were able to, working with staff and with the board, to come up with ways to make those loans more attractive, without sacrificing fiduciary principles. And I've been satisfied with that through the years. The second is there's an absolute ban on acquiring any employer security, real property, or loan. When the legislature adopted these, they either weren't aware of the fact or didn't care that under ERISA, you could go to the Labor Department and get exemptions from prohibited transactions, where actually you could convince the Labor Department that despite the potential or the theoretical conflict, it actually is something that could be in the interests of the overall plan. And we don't have that in California. So, the absolute ban was an absolute ban. So twice, in 1998 and 2002, legislation was enacted which creates exceptions from that rule. One was for our credit enhancement program, and the other was related to purchasing surplus real property from school districts. But we added to the legislation that the Ed Code fiduciary rules had to be complied with, and the Internal Revenue Code rules had to be complied with. And again, remember there was the exclusive benefit rule. And for the most part, through the years, the IRS has agreed to interpret that consistent with the way the Labor Department interprets prudence. So that pretty much has knocked the Internal Revenue Service out of the picture. They really have not, to my knowledge, ever come in and second-guessed the board for doing the kinds of things that you do with your credit enhancement program and your purchasing of surplus real property programs. The transactions involving self-dealing are, as I say, are the serious ones. The first one is using your authority as a fiduciary to benefit yourself. And that's what the trustee did back in, I guess it was 1982, 83, when he got one of his fellow board members to agree with him to invest in a piece of property where he had an undisclosed personal interest.
Tom?
Yeah. Going back to the conflict of interest transactions and things like that, one of our investment objectives or categories is infrastructure. If we wanted to buy an interest in a California toll road or water project or something like that, would you see that as coming within the ambit of those rules?
Probably so. We probably have to, address it and figure out, whether we would have to go and get a third exception from the absolute ban.
From the legislature.
Right.
And what about if a state agency sold taxable bonds such that the rate was attractive to us? Same thing?
If it could be interpreted as benefiting the state, then the answer would be yes. We would have to get a special ruling for that, a special exception for that too.
Yeah, all right. Last one I'm just sort of thing off the top of my head. University of California assets. Same thing.
I don't know, we would have to look to see whether that would fit under the contributing employer rubric somehow. The, University of California was really the state of California, and I'm not sure how that would come out. But that's the way to look at it.
Yeah.
We're not supposed to be benefiting the contributing employers. And state of California, people have argued that it's not a contributing employer, but we did a lot of research on that through the years and decided that it was, so made things more complicated for us. But that's a perfect example, though, both of your examples of why we need an exemption procedure. You could probably, in both those cases, if it was a private sector plan, persuade the Labor Department those were positive investment opportunities, but we don't have that. We don't have that. There's an absolute ban. As a lawyer, I'm not in favor of absolutes, but no one asked me at the time. Acting on behalf of an adverse party. At one time, I used to, in this one, I used to use, and this may be very popular with some of the board members, I used to use this as an example of board members receiving political contributions, and then using their authority on the board potentially to make an investment. At one time, this board made all of the investment decisions in real estate and private equity. I was successful in persuading two treasurers that they had to recuse themselves in some deals because we learned that they had received campaign contributions from parties who were involved in the particular investment opportunity. That was not a pleasant experience for me. So I'm glad the SEC took care of campaign contributions, so that's no longer an issue. And I don't have to face that. And I used, believe it or not, when I started, I used to have arguments with Jess Unruh about this. But he actually recused himself a couple of times. But then someone told me, well, you're a fool because he's lined up the votes before he recused himself. But it was after the fact, so by that time he was deceased, so I never had a chance to ask him. I'm sure he would have laughed at me. On those two kinds of prohibited transactions, you can recuse yourself from the decision-making and from getting involved in discussion. Some lawyers are looser on getting involved in a discussion than I am. I tend to be conservative on that. I think if someone has an interest, either personal or in behalf of an adverse party, they shouldn't be involved in discussion. A couple of years ago, the Labor Department added another rule, and that is that even if you recuse yourself, you may have to disclose the reason for the recusal if the information is actually material to the other board members. So in that, they did it in a situation where a board member was approached with an offer of a gift if he would use his authority to get the board to approve the investment, and he recused himself. But the Labor Department said that wasn't enough, that the other board members were entitled to know that he had been approached by this party. So he was forced to disclose the fact to the full board that he had been approached. And I think that was actually at the time I said to myself, I'm surprised it took us so long, the Labor Department so long to think of that, because it really is obvious. And then, of course, there's receiving kickbacks, and kickbacks are receiving something of value in return for a vote or another action. It's very difficult to prove. For a long time, the Justice Department was using other approaches to indict and convict people because they knew how hard it was to prove that someone had actually done something in response to a receipt of something. But the Supreme Court, knocked that out a couple of years ago. I used to talk about that all the time. So kickback is a kickback. You cannot recuse yourself. And obviously, it's probably the most serious thing and most serious violation that anybody, any fiduciary could possibly commit. Gratuities aren't necessarily kickbacks at all. Gratuities are some things that could be perfectly appropriate for you to receive under the right circumstances, but the consequences can be serious if you're not careful. You have a lot of rules here about when it is and is not permissible for you to accept meals and certain kinds of entertainment. The basic questions are, could the plan itself pay for it? Is it, would it be prudent for the plan to pay? Is it extravagant? Is there any evidence of a kickback intent? And is it consistent with your policy? Several years ago, a board member at Ohio STRS, the Teachers Fund in Ohio, was indicted and convicted of a misdemeanor when she accepted a dinner in New York from one of the Wall Street firms that was a vendor to Ohio STRS. The entire cost of the dinner was like $250, and it turned out that like half of that was for a bottle of wine that the vendors ordered and drank. She was not a drinker, but she went before a jury. Juries are usually not made up of people who go to New York and eat at fancy restaurants, and so she was convicted. One of her defenses was that the lawyers and the executive director for the fund told her it was okay because she was saving money for the fund. So even that wasn't enough to persuade the jury. So it's something you have to worry about and be aware of at all times, how things look. Those of you who have businesses, it's difficult sometimes to know whether a gratuity that's being offered to you is because of your business relationships or because of your CalSTRS service. So my advice is always, think about recusal if you think there's any question whatsoever about a particular thing. Again, since you don't make investment decisions like you once did, it doesn't come up like it once did. But, I've represented funds, Texas Teachers was a perfect example, where despite the fact the board members didn't make the decisions, the staff did. Board members were down in the staff, area trying to influence staff members to make certain investments. So it's something, to be concerned about. So that's how prudence and loyalty and prohibited transactions apply to investments, which is usually the bulk of what I do here and what I talk about. But they also apply to non-investment related duties. And I just want to mention, the areas where they do. We talked about planned benefit reductions last year. I think in light of what you heard today, I can skip over these slides, hopefully. But a couple years ago, there was a real issue before this board about, what happens if the legislature reduces benefits for members, and what are the duties of board members, and of course, for union appointees or those who are elected by unions now, I guess, and for those of you who represent, the state of California, there were some real potential conflicts. So I'll skip over those if you permit me to. In terms of funding issues, again, year after year, I've talked about, how you have to pay attention to funding issues. You have to listen to your actuary. You don't have to swallow everything you're told, but if you don't listen and you ignore your actuary's advice, you better have good reasons for doing so. So hopefully, we're going to be in a good position here for the next several years. So I don't ever have to bring these slides back. Something that comes up with claims always is, can we make exceptions for people? Can we do justice? And the answer generally is no. Similarly situated participants must be treated similarly. And I used to run into this all the time with my union plan clients, where they wanted to do justice, and it was difficult to talk them out of it, and sometimes I failed. Fair claims procedure, I know, Brian has paid a lot of attention to this and made sure that, there's no conflicts with legal staff being involved. And I believe, I know you've hired Chris Waddell to come in and be sort of an independent lawyer for you. So that problem has been solved. Trustees must follow the terms of the plan. You're only allowed to pay benefits allowed under the plan. And a very difficult one, and I've heard people from the public talk about this. It's a very difficult issue. You're required to make reasonable efforts to collect overpayments. And the one way we've looked at getting around that in some situations is, if the person has no assets, or if collecting an overpayment on a cost-benefit analysis isn't going to work, you're going to have to sue the person. How much is that going to cost? It's an extremely hard issue for most fiduciaries. When the plan itself makes a mistake, and then you're required by law to go after people for them, and make them repay. The pensions here are excellent, but they're not making people rich. So it's a difficult issue. Of course, you have a duty to limit expenses to amounts that are reasonable and appropriate, and I think this board and staff work very, very hard at doing that. And then finally, just liability. You're liable personally if you engage in any of the prohibited transactions I talked about. You may be required to restore losses, disgorge profits, and a court may order you to be removed. Since 1990, you are not personally liable for violating the duties of prudence, loyalty, and diversification, or acting in accordance with plan documents. At the time, and I'm still here, it's hard to believe, I argued that the board should not support that legislation because it was taking away from protection of the plan and of the members. But it was enacted into law, and I don't think it's done any harm through the years. I've never seen board members say, well, I don't care about prudence because I'm not going to be liable. So, but it's very unique to CalSTRS. I'm not aware of any other plan in the country that has this, and ERISA plans are not allowed to have this. They're not allowed to have clauses that relieve fiduciaries of liability for these kinds of violations. There are exceptions, though, to the rule. You are liable, even in these three areas, for gross negligence or fraud in the investment of plan assets. And you're liable for breach of fiduciary duty in connection with the administration of the plan. And there's no legislative history, so none of us know what was intended by the legislature in putting that in. And we had some legitimate worries in past years about actuarial considerations and setting the interest rate, and was that I'm sure that's not the kind of thing the legislators were thinking about, but that's one of the exceptions. So you are potentially liable for violations of fiduciary duty and administration of the plan, whatever that means. And as a lawyer, it always worries me when there's ambiguity, particularly if people could be held liable. So we just have to live with it. I don't know how to get around it. The co-fiduciary rules, you're held liable if you knowingly participate in somebody else's prohibited transaction violation, I guess would be the main thing to worry about, enabling it or you have knowledge of it. You're required to be a whistleblower. The Labor Department even has regulations that say you have to go to the Labor Department and blow the whistle on your fellow fiduciaries if you feel there's a violation. As a practical matter, I doubt that's ever been done, except for maybe political reasons in a union election scenario. And And then you're not, again, just, I'm sort of repeating myself, you're not liable for the actions of investment managers, so long as you're prudent in selecting them and monitoring them. But again, if you delegate to staff, you could be held potentially liable. And then finally, the final slide is the law actually requires CalSTRS to provide you with fiduciary insurance. In some states, boards are allowed to buy it, but here the legislature actually said you're required to buy it, which is a good thing, so you don't have to worry about when you buy it violating your fiduciary duty. We've had conversations in recent years about how much you should have. I don't think we've completely resolved that to my satisfaction, but I think for the most part we've resolved it to your satisfaction, so I'm willing to live with it. So that's basically my fiduciary lecture for the year, and thank you for your indulgence. And if anybody has any questions or comments, I'd be happy to hear them.
Thank you very much, Ian.
Okay, thank you.
Thank you. Items 10A, 10B, 10C, and 10D are consent action items. Does anyone want to pull any of the consent items? Okay. Do we have to take a vote on the consent items?
So 10A, B, C, and D. Yeah, they were put on your,
Yeah.
they were put on your, yours, wasn't it?
Good.
Only the clothes.
I think
Oh.
maybe they're coming now.
Ah.
Okay.
Just had a-
Go ahead, Michelle.
No, I just had a lagging question from Ian's thing. I didn't know the legislature required to do that. I thought it was optional whether or not we purchase fiduciary insurance.
Sounds like it's.
You guys got any questions?
I don't
Yeah, go
know.
ahead, go ahead.
Ask, have them come back up while these, thanks,
I think
Mary.
it is.
Okay.
I
Thank you,
just
Mary.
had a quick question about the fiduciary insurance. And in my mind, I thought it was, I thought it was permissive. I did not know it was required by the legislature.
Right.
So the state legislature requires it?
Yes.
Yes, it's Education Code Section 22259.
It's always, I don't know, I just felt like it was always given to us, like you can give us a check or you know what I
That's
mean?
personal law.
That's different.
Oh, sorry.
That's,
Sorry.
that's,
Okay, never mind. Never mind.
we're not covered, we're not covered
Yeah,
for
That's
the.
got it.
If the fiduciary insurance has a self-retention
That's other
that is
thing.
very substantial, and we pay our $10
Do they have to read
to
this?
hopefully get coverage on that amount, but
Got
it's,
it.
Yeah,
that's
well,
never
Okay,
been
so
answered
that's
very
separate.
well.
And the Labor Department had a difficult time with it. They finally had, there was so much political pressure that they approved it. For whatever you pay, $10 or $30, what that protects you against is the insurance company coming after you. If it turns out that you're found to have violated the law and they have to pay something in damages or losses. You don't have that from the state of California. And that's why I feel so strongly about, getting first dollar fiduciary insurance. So you never have to worry about anybody coming after you if, because, the fact that people are sued and sometimes lose doesn't mean they actually violated their fiduciary duty. Courts can be wrong, juries, in state court can be wrong, so.